Good morning, everyone. My name is Ana Ballesteros, and today I'm gonna give you a brief overview about the immigration detention system in Spain, paying attention to how evidence is handled. I would like to start by thanking the organizers for inviting me to participate in this workshop. It's a real pleasure to be able to contribute to this important conversation. I would like to start by geographically situating Spain because its location helps to better understand migration flows and at a certain extent responses to them. Spain is situated in the southern border of Spain, and the distance that separates Europe from Africa is 14 kilometers of sea. What is interesting is that Spain has an archipelago, the Canary Islands, located in the northeast of Africa, close to the south of Morocco and the north of the Sahara, and that Spain keeps two cities in Morocco, Ceuta and Melilla. Why these aspects are interesting? Because on March 1995, when the Schengen Agreement, which abolished internal borders within the EU, came into force, Ceuta and Melilla, and as a result, Spain, became the gateway to Europe, and the number of undocumented migrants attempting to reach the country increased. So it is currently impossible to understand migration policies and trends in Spain without taking into account the role that the European Union is playing in the configuration of border control and in the design of migration and detention policies. One relevant example is in this regard is the complex and multifaceted set of relations that both Spain and the EU maintain with Morocco. Despite this, it is important to highlight that only a minority of migrants and asylum seekers get into Spain using this route, both by land and sea, because according to the most recent data, they arrive via airport from Venezuela and Colombia. Another important point connected to this is the fact that Spain began to receive a significant number of migrants in the 19th of the 20th century. Before that, Spain was a country that people left due to political and economic reasons to Latin American countries and later on to other European countries. The first immigration law was passed in 1985, just before the entrance in the European Union and as a prerequisite to it. So what are the main characteristics of the immigration detention system in Spain? First, regarding detention facilities, in Spain, irregular migrants are detained in dedicated facilities, so-called Centers for the Internment of Foreigners, Centros de Internamiento de Extranjeros, spread all over the country. 7 in total at the moment, 5 in the continental Spain and 2 in the Canary Islands, although some of them are empty due to the COVID-19 pandemic. However, for shorter periods or before transfer to immigration detention centers, people can be detained in police stations or other more or less ad hoc facilities. In this sense, over the last years, one practice that was contested by activists and human rights organizations were the so-called fast-track deportations. This practice consists in, instead of detaining an undocumented migrant in a detention center, they go to a police station and the deportation is organized from there. So frequently migrants detainees don't have enough time to properly contact lawyers and or family and receive documents to appeal the deportation order. And furthermore, the government has started to create another kind of facility called Centros de Atención Temporal a Extranjeros, Centers for Temporary Care of Immigrants for receiving, in brackets, those migrants and asylum seekers arriving by boat to the south of the country, including the Canary Islands. They act as a kind of police station where people cannot be for more than 72 hours, although this not always is the case. Spain shows a great dynamism in developing mechanisms to receive or detain people arriving, because one of the structural characteristics of the model of migration is that it's very reactive in its response to the changeable migration flows. Second, maximum length of detention. The maximum period of detention in Spain is 60 days. Interestingly, Spain previously had a maximum detention period of 40 days. Along with other EU countries, it expanded detention limits after adopting the EU Return Directive. But Spain kept the length of detention way below the 18-month limit allowed in the Return Directive. Third, we don't have a system of alternatives to detention. 4, Spain does not detain or host children. However, we can see teenagers in detention because the authorities consider that they are over 18. And frequently, civil society organizations and migrant supporting groups denounce these violations of rights in front of the ombudsman. This is why the role of the lawyers in the process is so important. Finally, and importantly, the purpose of detention. The specific term, as mentioned, is internment. In immigration detention centers, the purpose is to guarantee the deportation of foreigners. Broadly speaking, a deportation can be either an administrative sanction for violating the immigration law, a consequence of a refusal of entry, a consequence of having been convicted of a crime, or as a substitution for a criminal conviction. Conversely, to Canada, establishing identity is not a reason for detention. It is true that when people arrive by boats to the southern border, they can be detained for a maximum of 72 hours in order to filiate them, give their fingerprints, etc. But authorities collect the data provided by the person. So a process of establishing identity beyond this self-declaration is never put in place, unless a deportation is ordered, so they need to get travel documents, etc. However, deportation processes depend highly on the country of origin. I am going to explain now how the process of detention is carried out, focusing on the factors that can be argued and the evidence that can be used during the process. In order to offer a general image, I would say that most of the people end up in immigration detention centers for 2 main reasons. First, living in the country without proper documentation, that is to say, when the person has no legal status. And second, when they attempt to enter the country without the documents required, which normally occurs when people arrive by land or boat to the southern border of Spain. Although this was not the case in the past, over the last years, in order to gain efficiency, people that have a deportation order because they are serving a sentence in prison are not normally transferred to immigration detention centers. Deportations are frequently carried out straight from prison the day they finish the sentence, and before that, the prison administration informs the national police in charge of immigration detentions and deportations in order to start the paperwork. If the deportation does not take place either from prison or immigration detention centers, the person is released. Let's examine the 2 scenarios previously mentioned and what is the process. For those living in the country without legal status, first, in these cases, if the person has an interaction with the police forces, they can start a deportation process, and within it, in some circumstances, they can propose the detention of the person. The circumstances listed in the law for justifying a detention are flight risk, obstruction of the deportation process, or danger to the public. However, there is ample room for arbitrariness in the use of these criteria that are not normally adequately supported in the file. Furthermore, according to the law, somebody without legal status cannot be deported if they have social, family, or economic ties in Spain, when it acts against the non-refoulement principle, if there is a risk for pregnant women or people sick, or when a refugee application is in process. The detention of the person is proposed by the police in accordance with the public prosecutor, and a judge has to approve it after listening all parties. All detainees have the right to duty counsel. Regrettably, oftentimes, this legal process ends up becoming a formality in the sense that very rarely the judge does not approve the detention. The judge has also to decide the period of detention, although very frequently the 60 days are considered by default. During the detention, there are some administrative processes, appeals, that the lawyer can start in order to stop the deportation, normally sustained in the elements previously indicated, like having family ties, the amount of time that the person has lived in Spain, etc. Either case, if the person is not deported in the period of 60 days, they have to be released. This deportation order prescribes after 2 years unless the removal order includes the prohibition of entry in the country for a certain period of time, in which case the time frame for the prescription may vary. The second reason for detention is for attempting to enter the country without the documents requested. In these cases, the administrative process is different and the name is different as well, and the person could be removed within the first 72 hours. However, during this period, detainees have the right to be assisted by a lawyer, to have an individual interview with them, and to speak with an interpreter. In theory, in this moment, the lawyer has to collect information about the circumstances that could motivate the revocation of the removal order, such as the right to international protection, being a minor, human trafficking, health issues, etc. In order for the person to be detained beyond 72 hours, they have to go in front of the judge for him to approve the removal order. But once again, if after 60 days the person is not deported, they have to be released. Currently, it is in discussion in court if after the person is released, the removal order is still in place and for how long. To conclude, I wanted to highlight 2 important points. First, in case of removal orders, not always people are detained, and this has been influenced by several factors, such as the capacity of the centers, the prospect for the migrants to be deported, which sometimes is related to the nationality and the existence of repatriation agreements, the workload of the police officer, etc. And all this makes this process very problematic. And sometimes judges who are sensitive with the controversial and contested nature of immigration detention argue that oftentimes lawyers are not well prepared and they don't even provide information about the possibility for asking for international protection because they didn't even inform their clients about this possibility. Thank you very much.